Good afternoon and welcome to the Black Business and Professional Association Ask a Professional. And today we have a very special guest, Efua Cobbina. And she is a lawyer who specializes in family law, known as the most difficult of law to ever do. That's what I'm told, Efua. And I just want to let people know a little bit about her. She obtained her bachelor's degree in civil and common law from McGill University, called to the bar in June 2009, articled with a prominent multinational Canadian law firm, and then in the spring of 2019 decided to launch her own practice, Efua Cobbina Law. And she has been doing that since December 2019. She regularly appears in the Ontario Court of Justice and the Superior Court of Justice, and is very settlement-minded. I gather does not like to actually have to go into court, would rather solve these things before. She's a member of the Black Female Lawyers Network, and she recently completed a 2-year term as director and member of the Canadian Association of Black Lawyers. Welcome, Efua. It's so nice to actually meet you and to hear more about this practice of law. And before you get started on your presentation, tell me a little bit about why this area of law has that notation of being so very, very difficult.
It's difficult, I think, primarily because people are often operating from an emotional standpoint. So you often have to talk your clients down into being reasonable or not being so emotional when trying to deal with issues. So from that perspective, it can be challenging because you're managing people, but you're also trying to get a resolution with all of the craziness that's going on as well.
Okay, so I invite you to do your presentation and then we'll ask some questions after.
Okay, so I just have a short presentation and I will put it up. Okay. All right. So what exactly is family law? So family law is the law that deals with families that are going through a divorce or separation. It deals with custody and access issues. It deals with property division in the event of separation. It also deals with child protection issues, adoptions, and part of the property that family law deals with is a matrimonial home, which is the home that married spouses live together in. So those are what we cover. The issues that are not part of family law that I often get asked questions about are elder law and wills and estates. So elder law deals with aging population and the issues related to either long-term planning or elder abuse or things that we've heard about in that area. And wills and estates deals with planning for your future. So having a power of attorney in place, having a will, having some type of estate planning to address what would happen in the event of someone's passing. So those are areas that are related to family law but do not fall under family law practice. So I've been asked to talk about COVID, family law and the new normal. So COVID-19 and what the impact has been. So when COVID-19 came about at its peak, on March 17th, immediately the courts closed and anything that was scheduled in the court was suspended automatically. At the time, very limited things were being heard by the courts, and the court made exception for very urgent matters to be heard by telephone or video conference. So that's what immediately happened in March. And then shortly thereafter, the court started to adapt to what was going on and started allowing more matters to be heard, not just urgent ones. So we were allowed to do telephone and video conferences and motions by telephone and video. And this is something that we weren't typically allowed to do before. So one of the direct impacts has been the courts getting into the 21st century and allowing us to have the court dates being heard virtually. So that actually represents a good cost savings for clients as well. And that's one of the positive things that's come out of all of this. We have also been allowed to book court dates electronically and online. And it might sound pretty simple and common, but that's not how things were done before. We were calling the court, trying to reach a trial coordinator, and then leaving messages, getting dates, trying to conference the dates with the clients and the other side. And by the time you would circle back, the date was often gone. So now we have online systems allowing us to book. So it's made things much more efficient. And we can also file our materials electronically. So instead of sending somebody to the court, which often can involve a 4 or 5 hour wait to file materials in a physical court record, now we're able to file things electronically. So that's been a welcome change. So each court deals with things differently. So there's different rules for the courts in Durham, in Peel Region, in Toronto, and Simcoe. So if you're questioning how things are done in a particular court, you have to look to each court to provide their direction. In general, when COVID came about, the courts really emphasized that people should be trying extra hard to resolve things outside of court. The court has very limited resources to begin with outside of the pandemic, and we were highly encouraged. There was actually a notice from the court. Sorry. There's actually a notice from the court encouraging people to try to resolve matters outside of court and to look to alternatives like arbitration or mediation and negotiation. I can talk a bit about those later on. All right, so the issues that we were seeing as a result of COVID-19 were most commonly parents having issues either seeing their children or wanting to prevent their children from seeing the other parent because of concerns about whether or not the other parent was following safety protocols for COVID-19. That was the most common issue that we were seeing. And then a lot of court orders were being breached as a result. So some parents were just deciding they weren't going to follow the court orders in place and weren't going to let the other parent see the children. There are also financial issues that naturally came about as well. COVID-19 also unfortunately resulted in a lot of people losing employment, and that impacted people's ability to pay support or to pay their mortgage or their rent. And this necessitated involvement of lawyers or the court sometimes to deal with financial issues that were coming about. So what is the new normal? The new normal that we're seeing now is a bit of a hybrid approach. So the courts reopened just last week on July 6th, but again, on a very limited basis. At this point, most courts are just hearing trials or pre-trial conferences, and they're still allowing most hearings to be done virtually. So we can still do conferences, we can still do motions by telephone or video. And we're hopeful, a lot of us in the family law bar are hopeful that we'll be allowed to continue some of this in the future and that it won't necessarily go back 100% to the way it was, because there's a lot of efficiency to be had by allowing us to do things digitally and virtually. So that's just kind of the introduction, and I'll leave it to you, Sandra. I know that there's some questions. I'm happy to answer those.
Okay, so I am very pleased to hear about the changes in the courts, because I do feel that that was really, could we take off the screen, please?
Sure.
Yes, the sharing. Yeah, I do feel that as you attested to, that it was very inefficient, and this constant coming back to court and having wasted a lot of time. I deal with the courts myself, so I know how much time. So going forward as a professional, how much time, how does that save your clients money, this ability to not have to be sending your clerk to court or you to court? How is that?
So the cost savings from not actually paying someone to physically go and file materials. So that's definitely something that you'll see right off the bat. But there's the cost savings for time. So most of us lawyers charge on an hourly rate basis. And if you had a motion or a case conference, sometimes you'll go to court, you'll be scheduled with 10 other matters on a list, and you can be waiting around all day to be heard, and your client's paying for that time. So now if you have a conference scheduled at 11, you are proceeding at 11 a.m. and your client's not paying for you to wait to be seen or heard in the courtroom. So there's definitely significant cost savings.
Excellent. That is excellent. So one thing that always comes up, what are some of the differences between common law and married spouses when it comes to the matrimonial home? That comes up a lot. So
It
talk us
does. It does. So as married spouses, you have different rights, and as common law spouses, you actually don't have any rights when it comes to a matrimonial home. So the matrimonial home is a home that married couple lives in, and if you're living in a common law, if your name is not on title, let's say your partner's name is on title to the house, you don't have any rights to that property. You don't have financial rights to the property, and you don't have the right to live in that property as if you were married. When you are married and you have a matrimonial home, your spouse, if you weren't on title, your spouse would need your permission to sell the home, to refinance the home, to transfer title, anything to be done with a matrimonial home, they need your consent, even if you're not on title. As a married spouse, you have the right to live in the home with your spouse, even if you are not on title. So you definitely have more protection under the law if you are married versus if you're not. And the matrimonial home, unless there is a marriage contract or what some people call a prenuptial agreement, you will share in the value of the matrimonial home if there is a separation. And that's a right as a married spouse. As a common law spouse, you don't have that automatic right.
But as a common law spouse, you can register the home tenants in common. Is there something that protects you if you register the home differently?
If you are tenants in common, then that means that you have an ownership interest in the house. So the two ways of holding title would be joint tenants, meaning that both of you own the property. If something happens to one of you, the other becomes the owner of the entire property. That's joint tenants. You have what's called a right of survivorship. So if you survive, then you become the owner of that property. If you're tenants in common, it doesn't mean necessarily that you own the property equally. You can own the property as tenants in common with one person, let's say, owning 90% and the other 10%. And that means that if the property is sold, you would divide the proceeds in accordance with that. And it would also mean that your consent is required for any transactions. But you can't just register a property as tenants in common unless the person who owns the title is agreeable to that. So if you purchase the property as tenants in common or joint tenants, then that's one thing. But if you end up moving into a property and your name is not on the house, you would need the other person to agree to add you as either a joint tenant or a tenant in common.
Would you say that a lot of people, particularly women, don't know this rule and have been living together for years and this is our house and something happens and they are thrown to the curb and they
Yeah.
have no rights?
I've definitely seen that. I've seen especially cases where a lot of people will put money into a property and think that they will be protected automatically because they contributed to the purchase of the property, but their name's not on title. And the other person has been able to sell the property without even telling them. So you can definitely protect yourself if you plan on moving into a property with somebody and contributing money, or you're both expecting that you'll be sharing in the value of that, then you should definitely have an agreement. You can have what's called a cohabitation agreement that sets out what your rights and obligations are for that property, so that if there is a separation, you won't just be kicked out and having to fight to get anything from that property.
Okay, so one person online, Kadi, says, what if the home was purchased before marriage and one wasn't on title? And if the home was lived in only for a year? Kadi, do you want to speak up and say your question? Maybe I'm not saying it well. Kadi Ann.
Hi, good afternoon.
Katie Ann, sorry.
Yes, hello, good afternoon. Yeah, the question pertains to if the home was purchased prior to marriage and I guess was only lived in by the couple for 1 year post marriage, is that still considered matrimonial home even though it was purchased before and the, call it, incoming spouse wasn't on title?
Yes, it is considered a matrimonial home, and this issue actually pops up quite often, and it can have really, really, I would say potentially financially devastating impact on one spouse. So if you owned a property and let's say you paid off the mortgage entirely and the house just has a lot of equity, if you've been married, you have to share in that equity with your spouse, even if you've been married for a short period of time. There's arguments you can make to not have to share it equally if it's a short-term marriage. But in general, if you own a property and you get married, then that asset becomes something that gets shared upon separation. So if that's the case, you would want a marriage contract to say at least the value of the property that you brought into the marriage should be protected, or that the property won't be divided at all in the event of separation. So the short answer is yes, it is a matrimonial home, and yes, you would have to share the value of that property.
So the advice would be get a prenup before you get married.
Yes, get a prenup, and you can get it before you get married or after. So there's no timeline on getting a marriage contract. So the American term is prenuptial agreement. We call it a marriage contract. You can get one at any point. So if you've been married for 10 years, you can get a marriage contract.
If the person agrees.
Exactly, if they agree.
If the person agrees. So are children treated any differently if married versus unmarried by the courts of Ontario?
That's just a good question. So they used to be treated differently, but it got changed just last year. So there were different rules. If you're married, we look at the Divorce Act. And if you're unmarried, we look at something called the Family Law Act. And before last year, for adult children of unmarried parents, if you were over the age of majority and you were not in school, you were no longer entitled to child support. But if your parents are married and the adult child is still dependent on their parents, and it could be because you're in school or you have an illness, there could still be entitlement to child support. But for unmarried children, they actually were not entitled to any child support for cases where there might have been a disability. So this was a case that somebody challenged the law on last year and got the law changed so that unmarried parents could get child support for adult children that had disabilities. So there was a difference. It was very unfair. We don't think it was necessarily intentional. It might have been an oversight in the law, but that's what the law said. And the courts struck that down last year and said that we have to treat the children the same because it's a form of discrimination to treat them differently just because their parents were married or unmarried.
Excellent. Back to the family home or the home. Do you lose your interest in your house if you decide you're the one who has to leave and move out, and the person is left and says, aha, I am here, I have rights, you have no more? Is that how it works?
That's not how it works. So if you are on title to the house, you're still entitled to any increase in the value of the house after you've left or whatnot. What you might be impacting if you move out is your ability to move back into the house with your former spouse. So if there's a lot of conflict and one spouse wants to live in the house and have the other ejected, if you move out, it's going to be difficult for you to return to your home and try to say, I should be the spouse to be living in the house until everything has been decided. That's because by moving out, you've shown the court that you have somewhere else to stay. And that's one of the criteria that a court will look at in deciding which spouse should be able to stay in a home. So your financial interest remains intact if you're on title, but otherwise you might risk your ability to live in the home if you leave without moving it in place.
What about though if it were because of abuse? You were being abused, you had to leave because you're in fear of your life, but you want to get back in your house. How does it work?
So if you do move out in a case of abuse, then you can go to court and bring an urgent motion. And you might be able to do that without letting the other side know, especially if you're scared of retaliation or concerned about that. You might be able to get an urgent court order saying that the other person has to move out and that you can move in. So we do see those cases, and definitely abuse is one of the things that a court would consider in that scenario. And if there's children as well, then most likely the person who's the primary caregiver of the children would be the one allowed to stay in the home, and the other person would have to be excluded.
Okay. Can you be separated and living under the same roof? We have heard of people for years. One lives upstairs, one lives downstairs, but they say they are separated. Under the law, are they?
If they have communicated, or at least one of them has communicated to the other that they want to be separated, then they are separated. Really? So we don't have a legal state of separation in Canada. You don't need to go to court and apply to be separated. If you've communicated to your spouse that you want to separate, then you are separated at that point. So yes, you can be living under the same roof and be separated. This often actually becomes an issue that's very contested because, as you said, some people for years, maybe even decades, have had separate bedrooms But then the question is, did they tell other people that they were separated? Did they continue to live as a family or as a couple? Were they going to weddings together? Were they going to events together? How did everyone else perceive them? Were they filing their taxes as a separate? So these are some of the things that a court will look at to say, were they actually separated or not? And this can be very important because you have a certain amount of time to make claims for property. So for people who are separated, you generally have 6 years from the date you're separated to make a claim to divide property. So if you have been separated for more than 10 years, then you might be out of luck in making a property claim. So we often see cases where people might say, well, we were separated, or others will say, no, we weren't separated. We lived in separate bedrooms, but we still presented ourselves as married, and it wouldn't be fair for there to be no property division in those cases.
Wow. So what is this? I've heard that you have to be separated for a year before being able to apply for a divorce. Is that true?
That's one of the criteria. So the most common criteria to get a divorce is being separated for a year. That's why the date of separation is important. The year exists also to let people see if they can reconcile or whatnot. So the court gives you a year of living separately, which again can be done under the same roof, before they'll grant a divorce. There are exceptions to that. You can get a divorce earlier than 1 year if there's been infidelity or if there's been physical or mental abuse in a marriage. But generally, the most common grounds for divorce that we see is being separated for 1 year.
How would one prove mental abuse?
Well, often times these days, especially, text messages and emails, that people sometimes leave written records of their abusive behavior, abusive language, so that can provide evidence. There might be third-party witnesses, or it might just be your word, your sworn testimony, either orally or in writing, that talks about the type of abuse that you've been subjected to. So you would have to provide some evidence in order to get a divorce on the grounds of verbal or mental abuse.
I see. So we're hearing you talk a lot about all the hard times when people walk into you. You are actually a counselor as well as a lawyer. So when someone comes to you, do you recommend mediation?
I often do recommend mediation if I think it will work for the parties. So I need to get a sense of what both people's personalities are like. If you have somebody who's very controlling and doesn't want to listen to anybody else, then mediation won't work. So you need to have two willing participants who want to come to the table and who want to resolve their issues. So if there's like a power imbalance, is one of the things that we screen for. If we feel that one client might be either intimidated by the other party with or without having a lawyer, then I wouldn't recommend mediation. But if both parties are fairly reasonable and they want to resolve the issues, mediation can often be a less expensive way of resolving issues. So depending on the people's circumstances, I often do recommend mediation.
So does one need a lawyer when you're going to mediation?
You don't need a lawyer. You don't need a lawyer for mediation, but it's highly advised that if you do come up with some type of agreement in mediation, you get legal advice. Because quite often you don't know what your rights are, and a mediator's job isn't to explain the law to either side. Their job is to find a middle ground and try to find a resolution. But if you don't know what your rights are, then you may be giving up or giving more than you should. So we definitely recommend at least get legal advice on whatever terms it is that you've come up with in mediation.
Okay. So Katie Ann asks, are individual RRSPs up for during a separation or a divorce? In other words, how do they get looked at? You have your own RRSPs getting divorced. Does that get into the pot?
Yes, it does.
He says.
Yes, you do. Yes, it is part of the assets that get divided. So the way that property is divided in Ontario is that we look at each spouse's net worth and how that's increased over the marriage. And the spouse who has a higher increase in net worth has to pay a sum of money to the other. So just to put that in clearer terms, let's say one spouse, their net worth increased by $100,000 over the marriage, and the other spouse is increased by $50,000. There's a $50,000 difference. To make them equal, because marriage is treated as a partnership, you would have to pay half of that difference to the other person to make you equal. So that person who's worth $50,000 more would have to pay their partner $25,000, and then that makes you both equal. So your RSPs would be part of that net worth calculation. So whatever you brought in for the RSPs, that's not included. It's just whatever increase you've had over the marriage for that asset.
So a good point. So what you bring into the marriage can stay your own. So if you had 10 properties before you got married and a nice little place in Jamaica, you keep that, or is that not how the court looks at it? Because one would think marriage is you bring your thing and you share, but that's not how the court looks at it.
So the exception to that rule, so generally, yes, what you bring in, you get to keep. The exception is the matrimonial home. So that's why that's a very contentious issue, because you can bring in a matrimonial home, you would have paid off all the mortgage and it's worth a lot of money. That gets shared regardless of the value when you brought it in. But other assets like an RSP, maybe if you had a timeshare somewhere, if you had shares, anything you had and you brought into the marriage, those you don't have to share the pre-marriage value. But for a property like a matrimonial home, you do. And to touch on that, you actually can have more than one matrimonial home, so you need to be careful. You can have, let's say, a vacation property in Jamaica. If you use that property as a family, that can also be considered a matrimonial home. So again, marriage contracts are a good idea if you do have a lot of assets that you could be concerned about.
Yeah, people seem very averse to marriage contracts. They feel that it says, they don't love me. If he loved me, we would share without all these arguments. What would you say to that? You know, how people worry over that. Oh, you know, I will never sign that. What would you say?
Well, I would say I look at it as an insurance policy, and in case something goes wrong, you want to know either what you're entitled to or what you want to know what you don't have to share. So from the perspective of someone going into a relationship who maybe doesn't have as many assets, you can come up with a marriage contract that is still fair. It might say something like, yes, my partner brought the matrimonial home in, but they brought it in with, you know, X amount of equity. I agree that they can keep whatever they brought in, but anything that we contributed to together while we lived together, that would get divided. So you can tailor your agreements to really suit your situation and make the agreements fair. Now, if you have an agreement that says, you know, one person keeps everything, especially in the case where, let's say, one parent might have been a stay-at-home parent, they don't have the financial ability to be independent, or they don't have all the resources. If there's an agreement that says they get nothing at the end of the day, then that wouldn't be fair. So you would want a marriage contract to have some equity in it and to reflect, you know, the contributions that both partners make. And it's not just financial. You know, raising a family is a non-financial significant contribution, and there should be some consideration for that.
Alana Salmon on the chat says, child support, big issue. When one parent's income exceeds the other parent income, it can be shocking, the required payment to the low income parent. Be careful who you have children with, she says. So Lana, do you want to expand a little bit on that? Lana? No, I guess she doesn't.
Yes,
Oh,
yes.
go ahead, go ahead.
Yes. It is quite shocking. That low income earner can all of a sudden say, oh, so I don't even bother work and you're going to have to pay me, because on the family law, both parents are expected to maintain equivalent lifestyle for a child or children. And there are professionals who are finding themselves in a deep corner of relationships, not knowing what it's going to cost them, not only to maintain the child if they get equal access, what they're going to have to pay the other spouse. And it is unbelievable.
Yes.
The lawyer should know what I'm talking about.
Yes, no, I definitely do. So if you're in a situation where you both have the children equally and one of you earns a lot more than the other, then the higher income earner is going to have to pay child support to the other person. And it can be, the amounts can be really significant. So yes, you definitely should I guess, consider these things when you decide who you're having children with. The
Yeah, so
possibility.
I don't think people realize it. You're in university, you meet somebody, uneducated, whatever, you get into this relationship. Next thing you know, you got pregnant, you graduate, you have a profession, and all of a sudden, that person says, okay, I can collect.
Yeah, so if they are caring, if they're sharing and caring for the kids, then you might have to pay child support. What would be worse is having to pay that person's spousal support. So that's also something that can happen because if
That
you,
is a big piece too, and people are applying for those things, and you're going to have to pay lawyers significantly to fight those kinds of decisions, because those are not 1 or 2 years. That could be 20 years of payments, which
exactly,
is substantial.
it can be substantial and it's not something that you necessarily plan for. So yeah, spousal support is definitely a very contentious issue as well.
So as a financial advisor, I'm warning single women who come and sit in front of me and telling me, I'm like, look, get an agreement.
Get a marriage contract, exactly. That can
Don't
save
set yourself
tens
up.
of thousands of dollars in the long run. It really can.
It's
So
a lot of money.
But can I also show the other side that has happened in the past? And what happened was usually the man got away with paying nothing to a woman who had been with him for a long time. Cleaned the house, managed the children, did all, just let me finish, did all of the things to help him look good, send him out in the world. He always had on the best suits, he had everything. And then he leaves her after he's now 20 years later feeling, wow, that's part of why the law got changed, because so many women were left with kids quite destitute. So I think there was an attempt to make it more fair. Am I wrong here?
No, you're definitely right. And the law right now, it's gender neutral. So it doesn't matter if you are the woman or the
Or the
man.
man, yeah.
So either of you can make that claim for spousal support, especially if you were the one caring for the children and you don't have any money. And in Ontario, the government has done a very good job of getting money from support payers. So if there is an order for support or even an agreement for support and the other person decides they just don't want to pay, there's a government agency called the Family Responsibility Office, and they have the right to take away your driver's license if you haven't paid. They can take away your passport. They can seize any money in your bank accounts. They can put liens on properties. They can even throw you in jail if you haven't paid child support. So the law in Ontario and most of Canada is very strong about collecting support from people.
The reason I'm bringing it up, people just don't realize that these rules exist, and they find themselves in very compromising positions. And it can be challenging. You're a young person just getting started in life, and all of a sudden, because you are better able, you now owe this person a fortune. And then they can, and I'm not talking about situations where it's a long-term relationship, they've clearly built something. I'm talking about very temporary relationships, and you happen to have a child, and whoa.
Mm-hmm. And I agree with you, Lana Salmon. It's called birth control.
I agree, but even
it's called birth control. We are
even
in
so,
2020.
accidents happen.
Not really.
Happen.
Half the time, people don't think about this, and you're right. You don't think about what your one night stand is going to cost you. Well, let's talk about that with our children. Birth control, 2020. It's a reality. And then the family lawyer gets to meet with the mother and the grandmother and the fighting. So I would ask you, Efua, what kind of personality is best suited to do family law?
I think you need to be able to leave your work at home. So you need to be empathetic, because oftentimes your clients are coming to you at the worst point in their lives. They're emotional, they're under distress. So you need to have empathy, but you also need to have good boundaries and know how to manage your clients and how to leave work at work and not bring it home with you. Because part of the reason why people find family law difficult is that it can be emotional. It can be difficult if you take on other people's burdens as your own. Obviously you want to fight. I fight for my clients passionately. I do fight, and I and I feel for them in their situations, but I have to be able to separate that and make sure that I'm being an effective advocate and not getting overly involved from an emotional standpoint. So I think personality-wise, somebody who has good boundaries, who's empathetic, a good listener as well, would be well suited for family law. And we deal with a lot of issues in family law. We deal with tax, we deal with real estate, we deal with corporate law. So it's also a very interesting area, and I really like it because usually no 2 days are alike. We're dealing with a lot of different issues, and it's always interesting.
Okay. One I had here too was the spouse, one person wants a divorce, the other one says no way. How do you get to move on from that? Because a lot of women particularly feel if the partner says, well, I'm not doing it, you can't make me, can they be made to be divorced?
Yes, they can be made. So if you have your 1 year of separation, then you can apply for a divorce, and the other person can respond or not respond. And if they don't respond, it's considered what we call an uncontested divorce. It's not being challenged, and you can get the divorce. So you don't need your former spouse to sign papers or to say they agree. You can apply for a divorce. There might be a hiccup if you need child support to be dealt with and it's not. Courts have the right to say we won't give you a divorce if there are children and there's no arrangements for child support. So that might be a hiccup if there are kids involved.
Really? They could say that?
Yes, because the courts the law doesn't want people to be able to move on and start another family if they haven't made arrangements to take care of their existing children. So that's why the judges, if you are applying for a divorce, they want to know, are there children? And if there are, where are they living and who's paying support?
And what happens if the partner says, well, that's your problem, I didn't ask for this? How does that work? I'm curious.
Well, if you know how much money they're making, then you can tell the court, this is what my partner's making, the children are with me, and the court can make an order for support. So if there's an order for support in place, then you can go ahead and get your divorce as well.
So another big issue that I've heard a lot with, particularly with children, it seems that the children get pulled in every direction usually. Let's call it a vindictive spouse or partner who won't give access to the children. The person is paying, one person is paying, and they won't give access, the person who has them most of the time. How does that get sorted?
You might have to go to court. So if you're dealing with a case where, let's say there is a court order and you're supposed to have the children on certain days and the other person's just refusing, then you might need to go to court and get an order. Sometimes it's very rare, but the court can give you an order that the police can enforce those provisions. So the police have the right to go get the children and bring them to where they need to be. It's not something that judges like to do because having the police take children from one parent can be traumatizing for them. But if there is a case where one parent has just shown a complete disregard for the law and the court orders, then the courts can have the police intervene to make sure that the other parent gets to see their children. And if you have that type of behavior that's consistent or persistent over a long period of time, then that person might risk losing their children. So we've had cases where typically it's mom, but not always. Let's say it's mom was refusing to let the children see dad, and she continued to defy court order after court order. She lost the children, and the children went to live with dad, and then she saw them on weekends or every other weekend. So you need to be careful if you're the one who's breaching those orders, because it could result in you losing primary care of your children or even having any contact with your kids, especially if they're a situation where one parent's trying to poison the children's mind or something.
That happens a lot, eh?
It does happen, and it's really sad. It's really sad.
When you meet a client, and it's your client, and you get the sense they're a poisoner, you ever talk to them about that?
Oh, I do. And if they won't listen, if they won't take my advice, then they're no longer my client. So that's another thing. I give my advice. You can choose to listen to it or not. But if you don't, and we don't see eye to eye, then I won't work with you, because that is very damaging to children, and that's not something I would ever encourage. So that's a very serious issue in family law called alienation, when one parent has is actively attempting to ruin the relationship with the other parent by poisoning them with lies or whatnot. And that can really have long-term psychological impact on the children.
Yeah. Do you ever get to meet the kids?
I've met kids occasionally. If a parent comes in to sign, they might bring the children, but not usually. Not usually.
Do they ever ask children in court? Who do they want to go with?
So it may not be as direct as that, but it oftentimes, if there is a conflict, the children may have their own lawyer. So the court can appoint a lawyer or request that a lawyer be appointed for the children. And oftentimes these lawyers are part of what's called the Office of the Children's Lawyer. So their job is to interview the children and to get a sense of what they want. For older children, normally they would get their own lawyer. For younger children, they would sometimes be interviewed by social workers. And they get interviewed over a period of time. They get interviewed when they're with mom, when they're with dad, or when they're with parent A or parent B. They get interviewed when they're at school so that the person can really get a sense of, is this the child's independent view? Are they being biased by one parent? And interviewing them on neutral grounds like school is something they do. So it may not be a direct question of who do you want to live with. They'll ask questions to get a sense of what the child wants, but then they're also looking at what's in the child's best interest. So a child may want to live with one parent who has no rules and lets them do whatever they want. But if that child's failing out of school or acting up in school, then a court can say, we recognize that the child wants this, but it's not good for them, and we're not going to make that order.
Okay, so do you have, if you were a teenager, are you able to say, I don't want to live with mom, I want to live with dad? Does the court listen to that if both parties have, you know, similar households, etc.? Would that be taken into consideration?
Yes, the older a child is, especially as a teenager, the more weight their opinion carries. And the reality is it's often very difficult to make a teenager be somewhere they don't want to be. So if they don't want to stay with one parent on one weekend, the term that we use in family law is that they vote with their feet. They'll just get up and leave. They'll take the bus, take the car, whatever, and go to the other parent's home, and they decide where they want to be. So especially for older children, their opinion definitely carries a lot of weight.
Wow, lots to think about. So you said family law is not just, you mentioned some other things, not just divorce and matrimonial homes. You mentioned taxes and real estate, you said?
Yeah, so those are other areas that definitely come into play. If you own a lot of properties together, or one person owns properties, we need to consider the real estate impact of things on separation agreements. So sometimes we have to consider, will there be taxes if certain properties are sold or transferred? What kind of consent you need to do certain actions with properties. So part of family law does involve considering real estate issues, and taxes are another important issue. If properties are being transferred, we want to try to do that in a way where you're not paying any unnecessary taxes.
Do you recommend, it sounds to me like anybody getting married should go immediately to a family lawyer before they get married. Do you ever get clients like that?
I do get clients who maybe they've heard from friends or they've been told maybe I should get a marriage contract. So we will get some clients who are planning on getting married and they want to know what their rights and obligations are. I find people who tend to want marriage contracts, it's usually people who are getting married for a second time, or maybe not even getting married. They're moving in with somebody and they want to protect themselves. But I think it should be part of that pre-marriage counseling is to consider, you know, speak to a lawyer just to know what you're getting yourself into, speak to a financial advisor as well, just to figure out how to set things up too. So I definitely think it's something that people should be exposed to before they're married.
And to Lana's point, they should also get counseling about birth control.
Yes, that as well.
No, I really find that we take this, many people take it very lax. Grandma says, oh, don't worry, I look after the baby. What a nice thing to have a baby. And they don't think through what the realities are of having a child and who is going to take care of it and what the responsibilities are. So maybe we should be giving more information about all these things to people. So, but coming to second marriages, you know, someone has died and the person is now older, have children and property, definitely get an agreement?
Yes, actually, I've done quite a few marriage contracts for couples that are getting together as seniors, and they've already accumulated their assets. They already know what they want to happen to their properties. So if they want to leave their properties for their children and make sure it doesn't get ensnared in a divorce dispute, then yes, they'll get a marriage contract that says, we've come in with our own assets, we will leave with our own assets, and the only things that we share are the things that we accumulate together. So for second marriage people, I think their eyes are usually wider open, especially if they've had perhaps not such a great experience from their initial divorce or separation. They want to make sure that they're protected going forward in their new relationship.
I have seen seniors who give their children what they plan to give if they're getting married later in life. So upon their death, there's no conflict as to who gets what, and that's probably a clean way to do it. Because I've also seen at death where even though there was an agreement that when this person died, his house would go to his child, and she already had a house, and then when he died, she didn't want to move. And it was very difficult for the child because he didn't want to fight with her, but it became a fight, even though it was documented. So.
Oh, it was documented. Wow.
Yeah, but then she changed her mind.
Wow.
It can go both ways. If you want to leave, this is again a little bit outside of family law, but I know a little bit about it. If you want to leave an asset for a child, you can decide to do a transfer while you're still alive, but then you may have to consider if you end up getting in a conflict with your child and that's their home, they can kick you out. So you want to make sure that you have a very good relationship and that you're fully aware of the consequences of that type of estate planning while you're still alive. So just those are things to consider as well.
Yes, because I have also heard of parents handing over the property to children and then the child put them in the basement.
Exactly. Yeah, that can happen.
Yeah. No, seriously, we have to say, oh, our children wouldn't do that, but
no.
We have to be careful. That's why I always say, have a good lawyer. Have a good lawyer and go see a lawyer. So we're going to end a little early today unless you have some other information for us, Efua. Final information to anybody considering using your services. Why they should. When should they?
Well, you should if you are entering into a relationship, if you are in a relationship. You can even just call if you have questions. So at my firm, we offer a free 30-minute consultation. So you can call us or email us to set that up, and we can advise you, regardless of what your situation is, how to best protect yourselves. Actually, I see someone asking for the contact information. I'm just going to share my screen that has that.
But somebody also said, what if you marry someone who already has children? Sorry, you cut me. I can't see. If you already have children, you brought them up as your own, but you later got divorced, would you have the same rights as a biological parent would? Could you seek joint custody? It's a very good question.
Yeah, that is a very good question. Yes, you could. If you've been acting as the parent to these children throughout the relationship, then you are considered, the term that we use is in loco parentis. You stand in the place of a parent, and you would have the same rights and obligations to seek custody, same rights and obligations when it comes to child support as well. So the fact that there are no blood ties doesn't impact that. So you've treated the children as your own. They recognize you as their parent. You have the right to ask for custody and have parenting time with those children.
Wow, interesting. Any other advice? You were starting to talk about your advice and we did move a little bit. Yeah, advice to anyone, why they should use a family lawyer. Why is it so important?
It's important, again, because there's a lot of things that we don't know or that we think we know and we've been misinformed about. So even something as simple as, when do I become a common law spouse? Some people think it's after 1 year of living together. That's not the case in family law. It's after 3 years of living together, you become a common law spouse.
Oh, see, I didn't know that. 3 years, eh?
3 years of living together, unless you have a child together and you're in a relationship of what we call some permanent. So if you have a child together and you've been living together for 2 years, you would be considered a spouse. And the reason that's important is once you're a spouse, you could have a claim or be required to pay spousal support. So if you want to protect yourself, depending on what your situation is, you should consult with a lawyer to figure out how to best, plan for the future and to take the necessary precautions. It's like having an insurance policy. You hope sometimes you don't need to use it, but it's good to know that you have protection in case you do need it.
Do you mind to stop sharing your screen so we can see your face a little bit?
Okay, sure.
Yeah, yeah. So again, you are saying, be prepared, think through things before things reach a stage, and talk to you. Usually before, but you know it's usually when panic sets in, they call you. Any other advice to people thinking of getting married, having seen what you've seen?
Yes, if you're thinking of getting married and you have assets in particular that you are concerned about, definitely call so we can have that discussion and I can give you some advice and information about what to do. There's something that actually I can just quickly mention that when you are married, if you inherit property or if you are gifted property or anything like that, that's not something that has to be shared if there is a divorce. So if you get something by way of gift or inheritance, it's not part of property division. Exception would be is if you, let's say you get some money and you decide to put it in your matrimonial home to pay off the mortgage, then you have to share that. So if you do get an inheritance or a gift, keep it separate. That would be part of my advice. Or if you plan on putting it into a joint asset, get an agreement that says that you'll be protected or you'll get that back.
What about your lottery win?
Your lottery winnings,
No, I'm
those
just
would,
curious.
yes, no, you would have to share that if you win the lottery during your marriage.
The family. I have a question. Do you
Yes.
have an estate lawyer in your company?
We don't have you said real estate or estate?
Estate.
No, we don't have an estate lawyer.
Oh, because that's so critical too.
It is, and I would love to bring somebody on board who does estates work. And I do a little bit of estates work, but not as much as I could be doing.
Mm-hmm.
I really focus on family law. Mm-hmm.
Right. Well, we want to thank you very much, Efua Cobbina, for your very great discussion and thoughtful answers. And you sound like somebody who definitely has that calm demeanor so that when people come in, they'll feel reassured that their issues will be well looked after. Thank you so very much.
Thank you for having me. This is a pleasure.
Thank you. And coming up next week on Ask a Professional, let's see who it is. It's Garcia Hanson Francis. She is she's a CEO and certified payroll expert. And she will be speaking next week on payroll tips and tricks. Ask Garcia. And also letting you know that this evening for the BBPA, we're going to be doing a conversation. I remember Little Jamaica When, and we're talking, hosted by myself. We're talking to two business people on the avenue, Benny Boo, who owns Benny Boo Styles, Wade Walters, who is known as Natty B. He owns Healing of the Nation Juice Bar, Valerie Steele, who has lived in the area for decades, and Dr. Jill Andrew, who is MPP for the area. So join us this evening at 6 and join us next week again for Ask a Professional. Thank you so much again, Efua Cobbina, for being here. Thank you.